All right, in this unit, we're going to focus on fiduciary duties in the corporation. Once we understand fiduciary duties in the corporation, in later units, we'll move on to fiduciary duties in the partnership and fiduciary duties in the LLC. As we are discussing fiduciary duties in the corporation, remember we're talking about the fiduciary duties of directors and executive officers. Sometimes I'll just say the director has a fiduciary duty, etc., or the director's fiduciary duty is as such, and you can take that to mean that the director or the executive officer has such a fiduciary duty. There are certain circumstances where the fiduciary duties of executive officers might differ from the fiduciary duties of directors, but largely they're the same and they overlap. Fiduciary duties are legal standards that are intended to reflect and respond to the agency problems and agency costs. What did we talk about? Well, if you're a principal and you give authority to an agent, you're worried that that agent is going to make bad decisions. You're worried that that agent is going to shirk, not do her job, or you're worried that that agent is going to steal from you. Stealing can take many forms. It could take clearly the most obvious form of stealing is just to embezzle money from the corporation. But usually stealing is a little bit more subtle. It involves conflict of interest. It involves self-dealing transactions. It involves transactions where the officer or the director is going to receive some sort of commission or kickback if the corporation enters into the transaction. And then there is the issue of corporate opportunity, where there is some sort of business opportunity out there and a director or executive officer takes that business opportunity for herself and does not let the corporation take that business opportunity. All right, let's talk about the labels of the fiduciary duties and the standards of liability. First, let's talk about the labels. These are generally how we label the fiduciary duties. We have a duty of care, a duty of loyalty, a duty of oversight, or the duty to monitor, duty of good faith, and there's a standard called waste. If I want to articulate it as a duty, I would say it is the duty not to commit waste. So the duty of care is about care in the decision-making process. Do the directors and the officers make their decisions after careful information gathering and deliberation? Duty of loyalty, that's about stealing. That duty addresses stealing and conflicts of interest. Duty of oversight, this is the duty of the officers and directors of a corporation to monitor the employees, the operations of the company and the company's business risk. Duty of good faith is just basically the duty of honesty. We'll explore that in a little bit more depth. And finally, there's the duty not to commit waste. It's basically the idea that you can't waste corporate assets. You can't burn money. You can't just give it away. All right. Let's talk about the duty of care and the standard of liability. So remember, the duty of care is about care in decision-making process. Do the directors and officers make their decisions after careful information gathering and careful deliberation, right? It does not focus on whether the directors or officers made a bad decision. So throw that out of your mind. If anytime you're looking at a duty of care fact pattern and you're thinking to yourself, the directors or officers breached their duty of care because this is clearly a bad decision, that's the wrong analysis. You want to look at their process. Did they engage in a careful decision-making process? All right, once again, the duty of care focuses on the decision-making process, not the decision itself. The standard of liability for the duty of care is gross negligence or recklessness. Depends on the court, depends on the jurisdiction, what term is used. Gross negligence or recklessness in the decision-making process. Once again, I want to stress, you focus on the process, to make the decision and not the decision itself. All right, let's talk about the duty of loyalty. Remember we said the duty of loyalty dealt with stealing from the corporation. The more subtle forms of stealing are self-dealing, where the corporation enters into a transaction with the director or officer, or kickbacks, the situation where the director or officer will receive some sort of commission from the other party if the corporation enters into the transaction. The standard, however, is a little bit more broad, and you'll see how it covers self-dealing and kickbacks. We ask ourselves, did the director or officer have a material financial interest in the transaction that we reasonably expect would influence her decision? Interestingly enough, the law does not prohibit conflicted transactions. The law requires the director to either show fairness or ratification. All right, so in other words, if the corporation enters into a transaction with the director, if the director is involved in self-dealing, or even if the director receives a kickback in the transaction, that does not mean that the director is automatically liable to the corporation for money damages. The director can still escape liability if the director or the officer proves fairness, that the transaction was fair to the corporation. And this includes procedural and substantive fairness. We'll talk about that in more detail a little bit later. Or the director can show ratification. Sometimes I like to use the word sanitization for this procedure. The idea is that the director has disclosed to the other directors that she is somehow interested in this transaction. She has a material financial interest in this transaction that would influence her decision. And the other directors still approve the transaction despite the self-dealing, despite the fact that one of their co-directors is conflicted in the transaction. This is called ratification. We'll go through the details of ratification in a little more detail a little bit later. All right, so what's the standard of liability for the duty of loyalty? We already talked about it. The director is not automatically liable for engaging in a self-dealing transaction. She can escape liability if she shows the transaction was fair to the corporation, or if she shows that the other directors ratified the transaction, either before or after the transaction. There is another duty of loyalty fact pattern called corporate opportunity. We've already discussed it. It could be corporate opportunity. It could be called business opportunity. It could be called usurping a business opportunity. This is where the director or officer takes a business opportunity for herself and does not let the corporation have it. Once again, the director can escape liability to the corporation for taking a corporate opportunity if the director shows that it was fair for her to take the opportunity. And we'll discuss what factors play into the decision of whether it was fair for the director to take the opportunity, or ratification. If the other directors said in a formal approval process that that director could take the opportunity and that the corporation does not want the opportunity. So once again, in the corporate opportunity context, a director who takes a corporate opportunity can escape liability if the director can either show that it was fair for her to take the opportunity, or that the other directors ratified her taking the opportunity. They approved it. They sanitized the transaction. They sanitized taking the corporate opportunity. Duty to monitor, or the duty of oversight. So usually this involves one of two situations where we have the board of directors or the executive officers, but the board of directors failed to detect or prevent employee misconduct, some sort of employee misconduct. It was either illegal conduct or some sort of conduct that was harmful to the corporation. For example, we might not have caught our employees embezzling from the corporation, and because the employees embezzled from the corporation suffered harm. are the directors who failed to detect this liable for this failure on their part? Or there might be situations where the board didn't even consider a transaction. There was some sort of transaction that the board should have entered into or could have entered into, and now the shareholders are unhappy that the failure to enter this transaction has somehow harmed the corporation. The board of directors didn't even consider it. Will they be liable for failure to meet the standards under the duty to monitor, or also called the duty of oversight? So here's the standard of liability. The directors or the officers are only liable if their failure to act was not in good faith. So if we are a board of directors and we are monitoring our employees and we don't catch our employees get away with something, our employees somehow cause harm to the corporation, we are only liable if our failure to detect or prevent this misconduct was not in good faith, right? And here's the standards for not in good faith. We acted not in good faith if we had an intent to cause harm to the corporation. We as directors or officers failing to prevent something or failing to engage in some sort of transaction, it's very difficult to prove that we intended to harm the corporation. Might be the case, but I think those cases are rare, and even in those rare cases, I think it's difficult to prove that directors or officers, in failing to monitor the conduct of employees, intended to cause harm to the corporation. Second one is a little bit easier, but still a very difficult cause of action to prove, that the directors or officers acted in conscious disregard of their duty to act. And we'll discuss what types of conduct might be conscious disregard of their duty to act in later slides. Let's talk about the duty of good faith, right? So generally, we have the duty of care, the duty of loyalty, the duty to monitor, and then we have this general duty of good faith. Directors and officers must act in good faith. We already talked about the standard of liability for not acting in good faith when we talked about the duty to monitor. And in essence, if you intend to cause harm to the corporation, you have not acted in good faith. Or if you act with conscious disregard, or you fail to act with conscious disregard to a duty to act, you have a duty to act and you consciously disregard that duty to act, then you have not acted in good faith. Waste. Let's talk about waste. The whole idea of waste is, this is what I think about waste. The actions of the directors, the decision by the directors or the executive officers was tantamount to burning money, right? Burning money is just waste. There's no good that can come of it. So that is the standard of waste that I like to think about. Of course, there is a legal articulation of the standard that no rational person would have thought that the decision would benefit the corporation. And look how it's phrased. It's saying no rational person would have thought this way. That means if there was one rational person who could have thought this way, then it's not waste. Waste is very difficult to prove. When a shareholder is unhappy about a corporate decision and they sue the directors for waste, it is very difficult to prove, right? The shareholder might make lots of arguments that this was a bad decision, but the standard is that no rational person would have thought that this decision would benefit the corporation. All right, let's talk about the business judgment rule. If the court applies the business judgment rule to the transaction, the directors are going away scot-free. So in other words, if we are a shareholder and we are suing the board of directors for a breach of their fiduciary duties and the court applies the business judgment rule, that means we, the shareholder plaintiffs, are losing our case. And this is the business judgment rule. And you'll see it phrased in many different ways, but a court will not second guess a decision of the directors unless the directors breach their fiduciary duties. In other words, if you want to hold the directors liable for some sort of decision they made and the harm that decision caused to the corporation, you have to show that they somehow breached their fiduciary duties, right? And what you're going to have to show is that they breached their duty of care by engaging in some sort of grossly negligent or reckless decision-making process, that there was some sort of conflict of interest, and that the directors can't prove fairness, or they can't prove that there was ratification, that one of the directors took a corporate opportunity and can't prove fairness and can't prove ratification, or that one of the directors had an intent to harm the corporation or failed to act in conscious disregard of a duty to act, or the directors engaged in waste. As you look at all of those possible breaches of fiduciary duties, you'll notice that they are difficult for a shareholder plaintiff to prove. The burden of showing that directors or executive officers breached their fiduciary duties is very high. Let's talk about the exculpation clause. We'll talk about this in a lot more detail later, but let's get the basic idea. Corporate laws generally provide that a corporation's articles of incorporation may have an article that exculpates directors and officers, not officers, directors, that exculpates directors for breaches of their fiduciary duties. Now, as it turns out, the effect of the law is that the articles of incorporation of a corporation can have a provision that exculpates directors for breaches of their duty of care only. So, the exculpation clause in the articles cannot protect officers. It can only protect directors. The exculpation clause cannot protect directors for breaches of their duty of loyalty. It cannot protect directors or officers for conduct that was not in good faith, and it cannot protect directors or officers for conduct that is considered waste. So, once again, a corporation's articles of incorporation may have an article that exculpates directors and officers for their fiduciary duty of care, not for any other type of fiduciary duty breach. Also, this exculpation clause cannot protect officers. It only protects directors.